Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to talk about dissolution of corporations in Illinois. We're going to talk about how to dissolve a corporation, why you should dissolve a corporation, and the difference between involuntarily dissolving a corporation and voluntarily dissolving a corporation. Let's start by talking about the difference between voluntary dissolution and involuntary dissolution. A corporation can be involuntarily dissolved by a court order if creditors file suit against the corporation, or by the Secretary of State if the corporation fails to file its annual report. If the corporation is involuntarily dissolved, then any creditors seeking that have corporate debts can pursue the directors and officers of the corporation after the dissolution of the corporation for they'll basically make the directors and officers personally liable for corporate debts if the corporation is improperly or involuntarily dissolved. If the corporation is voluntarily dissolved by consent of the shareholders or a shareholder vote and properly wound up, that means concluding the corporate business, and we'll talk about what winding up is and how that works later. But if everything's done properly and the corporation is voluntarily dissolved, then any directors and officers of the corporation won't be personally liable for corporate debt after the voluntary dissolution of the corporation. So voluntarily dissolving a corporation basically cuts off any liability that the officers and directors may have for corporate actions, either during the time that the corporation was active or during the dissolution process. So what happens if you've already been involuntarily dissolved as a corporation? You haven't filed your annual report and the Secretary of State has involuntarily dissolved you. And let's say you don't want to continue transacting business. Should you just stay put and keep your involuntary dissolution, or should you take some action to voluntarily dissolve your corporation? That really depends on the nature of your corporation. So if you have been involuntarily dissolved by the Secretary of State, you can get your corporation reinstated. You have to pay some extra fees to do so and file any delinquent annual reports. You file something called Articles of Reinstatement with the Secretary of State to do that. Then once your corporation is reinstated, you can follow the process that we're going to talk about to voluntarily dissolve it. So even if you've been involuntarily dissolved, you can still go through the voluntary dissolution process to cut off liability of shareholders and directors. Officers and directors. So when does it make sense to do this? Because you got to pay some fees to the Secretary of State. You may have to pay an attorney to help you out with this. It makes sense to do this if you've actually transacted business and you've interacted with other people, which could cause potential liability. So if your corporation is a one-person corporation that you set up for a venture you are intending to embark on and you never really got started, you didn't incur any potential liability, then involuntary dissolution from the Secretary of State is fine. No need to reinstate your corporation and voluntarily dissolve. However, if you were operating for a couple of years, contracting with people, if there's potential that someone can sue your corporation for anything, then it almost always makes sense to follow the voluntary dissolution process rather than let the Secretary of State involuntarily dissolve you, because the cost of getting reinstated and going through the voluntary dissolution process is probably going to pale in comparison to any liability you as a director or officer might incur after the involuntary dissolution of the corporation. Because remember, if your corporation is involuntarily dissolved, you as a corporate officer are liable for any corporate actions, which kind of defeats the purpose of the corporation entirely. So you paid to get the corporation set up, you manage your corporate book. If you get involuntarily dissolved then and don't remedy that through a voluntary dissolution process, you might be on the hook for corporate debt anyway, and everything you did wasn't worth doing in the first place. So if you have potentially incurred liability, it makes sense to voluntarily dissolve rather than involuntarily dissolve. So let's talk about the steps to voluntarily dissolving a corporation. Step 1 is obtaining shareholder consent. Step 2 is informing the Secretary of State that you're involuntarily dissolving. And step 3 is winding up corporate affairs. So we'll go through these one by one and explain them. Step 1, obtaining shareholder consent, is pretty simple. That the process for the internal process for dissolving a corporation is either getting unanimous shareholder consent to dissolve a corporation, or holding a vote of shareholders and getting the amount of votes required in the bylaws, or if the bylaws are silent on the subject, a 2/3 vote of shareholders will dissolve the corporation. you have to provide notice of the vote. And in our article at learn-about-law.com that's connected with this video, we have a little bit more detail on what notice requirements typically are. So it's important to follow these procedures to the T when dissolving a corporation, because if you improperly dissolve a corporation without obtaining shareholder consent or properly giving notice and getting the required number of votes, then you may be liable as a director to the shareholders. So the dissolution process is all about cutting off liability for directors and officers. Step one is making sure you cut off any liability to the shareholders you might have, and that consists of going through the proper internal dissolution procedures and going through the voting process or getting shareholder consent. So step two, once you've voted to dissolve the corporation or obtain shareholder consent, is to file articles of dissolution with the Secretary of State. These articles of dissolution basically let the Secretary of State know that you're dissolving and terminate your responsibility to continue filing annual reports and paying annual fees. So you want to do this pretty soon after you've dissolved so that another annual report doesn't become due, because if the annual report becomes due before you file the articles of dissolution, even if you've already voted to dissolve, you're going to have to pay the annual report fee in addition to the minuscule fee that's associated with the articles of dissolution. So you've now voted to dissolve the company or gotten shareholder consent. You filed articles of dissolution with the Secretary of State. The last piece of the puzzle is winding up the business affairs of the corporation. And this basically consists of liquidating the corporation's assets, paying any taxes that are owed, paying off any creditors, and then distributing the rest to the shareholders and creating a report of what you're doing so that you can prove, if ever called to answer for your actions, that everything was done in the proper order and all the assets went to who they were supposed to. So the first step, we'll go over the steps you should take in order to wind up a corporation here. The first step is providing notice to the creditors. So within 60 days of the actual vote to dissolve the corporation, you should mail notice to any creditors of the corporation. And the notice has to inform the creditors the date that the corporation was dissolved, the mailing address to which each creditor should send any claims if they're owed money, the deadline for creditors to file claims, which must be at least 120 days from the date of dissolution, and that if the basically notify the creditor that if the corporation doesn't receive a claim by the deadline, then their claim will be barred and any liability for that claim will be cut off. So this is basically starting the clock ticking, and once you send this notice, the creditors will have 120 days to file a claim that they're owed something after the date of the dissolution. If they don't file a claim saying they're owed something, then any money that the corporation owes them is cut off. Their claims are barred, and they don't, unless they didn't receive notice or they can claim that there was something improper with the notice, their claim is wiped out. So next, after you've gotten all of the claims in, you should prepare a distribution report. And during this whole process, you should be cataloging assets and liquidating them and basically creating an account with money in it to distribute. The distribution report will tell creditors and shareholders how much money has been collected and who it's going to. So you're going to have an inventory of all the assets that you've collected, and then you're going to have a list of all the creditors and how much each creditor is receiving, and then a list of all the shareholders and how much each shareholder is receiving. One important thing to note is that creditors have to be paid off in order of priority. So there's different classes of creditors, and we have articles about this at learn-about-law.com. We won't go into detail here, but each class of creditors has to be paid off in priority before you get to the next class, and creditors have to be paid before shareholders. And taxes should be paid before creditors. So a key here is working with an attorney to make sure you're paying people off in the right order, and making sure that if there's not enough money to go around, all the creditors in whatever the last class that you're paying is get paid in basically an equal pro rata share. It's important to do this right, because winding up the corporation incorrectly might be just as bad as not winding it up at all, because any creditor that doesn't get what they should have gotten from this can then sue you personally as an officer and director, claiming that you improperly wound up the corporation. So it's important to wind up the corporation and voluntarily dissolve. It's also important to do it right and make sure that the right people get paid. Now, this should be easy because you'll have all of the creditors' claims and you'll know exactly who claims to be owed money. And then the next trick is just putting those claims in the right order and making sure they get paid paid the right amount. But that's the report. Before you pay off any creditors, you pay any taxes that the corporation owns. Then you pay off creditors according to the amount shown in the report. And then any remaining assets are going to be distributed to the shareholders. Often, if you're dissolving the corporation, there probably aren't a lot of assets left to distribute to the shareholders, but the assets should be distributed based on the percentage of ownership unless the bylaws state something else. So sometimes there's different classes of shares, and one class will be paid off before the other. But again, it's important to do this right, so you should definitely contact an attorney to work with you and make sure that you're checking all your boxes and dissolving appropriately, because the whole point of starting a corporation and the point of voluntarily and properly dissolving it is to cut off liability. And if you don't do it right, then your personal liability won't necessarily be cut off. Thanks so much for listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.